Hello there, good morning, and thank you for choosing us this morning. Time to review the news. A lot has been happening. It's quite an eventful week already. It's just day 2 in the week. The newspapers reporting a lot. I shall just quickly run you through the headlines in the newspapers this morning. Let's start with the Daily Graphic. So this morning, courts will serve all fairly. CJ nominee pledges adverting. Yesterday was quite an eventful one at the appointment committee. And you're interested in that even before we get on the table to discuss everything that unfolded, you can grab a copy of the Daily Graphic and take a read. It will be on page 3, not to clear hair, but normally the culture is the biggest story will be on page 3 when you start the reading in front of it. And as well, nation's oil industry facing sharp decline, Energy Minister warns. Stories on page 11 of the Daily Graphic this morning. And Ghana signs bilateral debt agreement with Germany as well in the Daily Graphic. And behind the Daily Graphic, 25 nabbed over illegal gold trading. Story is at the back page of the Daily Graphic. Could you at some point, you may want to tell us some details in this 25 persons that have been arrested for illegal gold trading? Are they companies or they just individuals?
Companies and individuals, but these individuals are like CEOs of these companies and associates of these companies. I mean, if you look at it, for example, it says the arrested individuals include Gabriel Sewono, Ghanaian, CEO of Legend Precious Metal; Lucia Al-Yazigi, former Belarusian diplomat and lawyer. Duncan Finlay Massins, I hope, British investment banker. Eric Manuel Belloran Perun is Argentine. Dominic Vasilikovic and Panagostis Jordanidis, Swedish nationals. Alex Ivanov, Russian national, and several Ghanaians. Emmanuel McAddy, Kwesi Opare, Gilbert Nojro, Madeleine Echode Iyaboa, Charles Ohiming, Francis Atta, Michael Na, Stephen Hansen, Clement Agbaglo, Haruna Adams, Jerry Nanu Glee, and Chris Achichogbe.
You did amazing with the foreign names and even the ever name. Quite excellent. Okay, we'll move to the Supreme newspaper. If my screen will just come back on, we'll see if I can write. We're done with the Daily Graphic. Let's go to the other newspapers. The Daily Guide. Okay, well, Supreme newspaper reporting on the 29th GJA Media Awards, of course, where multimedia picked up a lot of awards. Jumfor urges Sutumfor to use his influence to fight Galamsey. That is in the Supreme this morning. And yesterday I was telling you how John Boydu has made quite a good comeback and is seeking to be the chairman of the NPP. We'll be following it to see how that would also pan out. And behind the Supreme, it's some update on sports. Let's go to the new finder. Business hint at possible price reduction. Is this good news? Especially because in January, your minimum wage is increased by 9%. Does this mean that very soon you shall be buying stuff at a lower price or what? Will that culminate into quite affordable goods and services in this country? But you take a read and then you have an update. Gold hits 2 weeks high amid U.S. economic concerns. And GSE ends week lower despite Friday rebound. And as well, petroleum sector arrears rise to 2.8 million USD as oil revenues as well slump. Kuvia J and I did some analysis on the first time we opened that valve when former President Atta Mills, when we first found oil, and we've just been digging that. What exactly have we been doing with our oil reserves, the money that comes out from that? And we're interested to know that it looks like all of the pressure or the bigger pressure is on oil revenue, education, agriculture, road and all of that is on oil. And so if there's pressure on it, it's not surprising. But daily analysts as well, no sacred cows in Galamsey fight. The president, when he was at the GJA, the Ghana Journalists Association Awards over the weekend, he's been still warning about persons who are involved in illegal mining. The government increases public sector salaries, minimum wage by 9%. That's it. That's it. Is this one to clap for the current government for? It's not strange, is it?
No, it's 9%, really. But you see, I think that when we take it from the top, we might not really see it quite clearly. Last time, some people were discussing, and I said, okay, the 9%, the daily minimum wage is around, is it 13 or 14?
Currently.
Yeah, or 20, no, I think it's 20-something cents, which means that in a week, when you work 5 days, your salary will not be close to 200.
Why are you doing this math?
No. So look at it at the end of the month. Someone may be taking around 480 something. Really?
Yeah.
That
with 4 children.
That if I don't pay you nothing at all, it shouldn't be below 400 and something.
With 4 children.
That's how much.
2 of them women who have to buy something.
I think that we should be frank with ourselves and do better.
I hope
the government has done its bit, but we need to probably sit around as a country, not government, but as a state, and find out how do we, adequately compensate people for what they do. Because 400 and some, less than 500 cedis, if I pay someone even 1,005, I feel what is the person going to do with 1,005? How much more less than 500 cedis? Minimum wage. No, we should do better. We should peg the minimum wage at, say, even 5,000. So that you and I, if they don't pay us at all.
I didn't see that coming. Thank you. But still on GJA calling for Mohammed's declaration to end Galamsey is on the daily analyst this morning. We'll quickly go to the overseer. Gold board arrest 25 for illegal gold trading and fabrication. And Kojo's been giving you an update on that and about how Ghana signed new bilateral debt agreements with Germany as well. It's on the overseer this morning. Yeah. Let's go to the next newspaper, Daily Guide, which will be the last one, of course.
But before you go there, please, in the overseer, there's a story that is of interest to me and the people in the Western region. Takrady market project to resume next year, Finance Minister assures.
In fact, he says that it's part of the priority.
We're going to keep an eye on that, because Takrady market cycle is vital.
It will find expression in the 2026 budget to be read on.
He says, so we'll keep an eye on that.
Okay.
From January, we'll keep asking.
Honestly, together with you, we'll keep an eye on it.
Good. This one will go for until Mr. Minister hasn't kind of
Well, the Daily Guide as well. Minority boycott CJ nominee amid drama. GJ is still calling for Mensah declare end to Galamsey. Now, we shall be talking about this extensively as to whether the minority indeed walked to the appointment committee already, knowing that we're going to stage a walkout, despite the majority indicating on PM Express some weeks ago that boycotting and walking out is definitely not an option.
Yeah.
Another story that will interest you, Kojo, is jailed coup plotter gets 2.5 million bail. Yes, if you recall the story about how some people were planning a coup against Akufo-Addo at the time. Well, he was sentenced to death, actually, at the time. And yet there's an appeal on that. And so pending his appeal and all of the other legal terminologies that the lawyers can explain to us about, he has been granted a 2.5 million bail. Because that is quite the highest treason of this London. So I'm not surprised at the
Okay, exactly. Yeah, it's true.
Okay, that's it. Maybe if you're kind, I shall bring you some updates on My Joy Online. But otherwise, of course, you know your way around My Joy Online. Just go on there, www.myjoyonline.com, and take a read. What's really the news without myjoyonline.com? That will be all for the headlines. We'll get into the newspapers just shortly.
All right, okay. Thank you very much. So that's, MFR Koshadity with the headlines there. Let's get into the details. And joining us is Dixon Chredia, MP, Brekum West. He is a sports enthusiast. So yes, of course, when we have him here. And he's a member of the Environment Committee as well. So tomorrow, maybe, likely, he will be leaving Ghana to join COP to see what he will be giving us. Thank you for coming, Honorable. And then we're also joined by a lawyer, who's making his debut on the show. Very, very fine looking.
It's not his debut.
It's not. Oh, then okay. Okay.
I'll be joining via Zoom.
This is the first.
Yeah, it's not a debut at all.
Okay, so debut in the studio.
In person.
Yes.
In person. Okay, it means that I'm not entirely wrong. Yeah. How are you, sir?
I'm doing great. How are you doing?
I'm well.
Thank you.
Honorable.
Kojo? Yeah, sure.
So let's start as we do always. Give you maximum of 2 minutes. Tell us what you feel you want to talk about before we get into the papers.
Kojo, let me say a very big good morning to my big brother, Dr. George Atabuatan, the Director General, National Signals Bureau,
Okay.
Over the weekend, he was bereaved. Oh. Yeah, that was the funeral of his late mom. So we were all in Brekum to commiserate with him. Okay. I wish him all the best today. Same to the Bono Regional Communications Officer, my very brother Charles Akowua of Bui Power. His father passed on, and Saturday was the final funeral. So the weekend was not good for us in the Bono region, especially those of us from NDC. And I wish them good strength. May God guide them all the way. One important thing I want to talk about is the 50% increase in the student loan scheme. 50%. You know, prior to this announcement, students were being given approximately 2,000, 2,500, and now it is going to go up to about 4,500 per student. And this is on the back of the stress-free fee policy that this government has introduced. So what that means is all level 100 students are not going to pay the fees. On top of that, the student loan has been doubled to make the lives of students at the tertiary very, very comfortable. The underlying principle is that under this government, nobody should be left behind in terms of pursuit of tertiary education. Because you know, basic is free at the GHS level, secondary is free, and tertiary is where the major challenges are. Last year alone in Brekum West, 317 students got admissions at various tertiary institutions, but were not able to pursue as a result of lack of funding support. With the stress-free policy, where virtually first-year students wouldn't be paying any fees, and on top of that, being given about 4,500 Ghana a year will be enough cushion for each and everyone to benefit. So for me in Brekum West, on top of this, I've also launched Brekum West Education Fund, also to support every tertiary student in Brekum West. So very good news. And another significant aspect of this policy, the new direction the Student Loan Trust is going, is that before this announcement, the interest rate on the loan was 12% compound interest. 12% compound. Now it's been slashed to 6% simple interest. Okay. And that is a huge relief for students. So I would like to take this opportunity once again to commend His Excellency John Dramani Mahama, who is now deepening the rights of each and every Ghanaian to get to the highest level. You know, it's a constitutional right that education is a right for everybody. But because we don't have the resources, we've limited its availability freely at the basic and at the senior high. But the Constitution says there should be conscious attempt to make it free at the tertiary as well. I thought the Constitution said free basic. No, basic, secondary, and tertiary, and gradually making it conscious effort should be made to make it free at all levels. Okay. But now it is at the basic and secondary school. And these policies are geared towards that direction. So I'm very excited about that. Okay. And Kojo, before I land, you talked about COP30. Let me warn that the biggest existential threat to humankind is the climate change. And we should all play our part. COP30 in Berlin, in Brazil, is such a critical conference, if I should put it, to define. Because,
when will we move from the talks,
the rhetorics to action?
To action. We've been having COPs over the years.
That is why each and everyone would have to play their own, the little they can do. Because you're at your own level. I know you are into rice farming, aren't you?
Yes, yes, yes.
And you know, rice farming is one of the major sources of methane. And methane is 28 times more dangerous than carbon dioxide in terms of contribution to climate change. So how do you reduce and mitigate production of methane in your rice production? And these are the support we should be providing, the education and the support government should be providing
that is why
to reduce methane production.
But that's why, because we can't say we're going to reduce rice.
Not at all. You need it for food security.
Exactly.
So how do you balance it? You need
the forest reserves. You need to make sure the trees are
exactly. These are some of the things. And we also have technology that will allow you to go into massive rice production and mitigating production of methane. Okay. So these are measures we should be doing. So it is about time the issues of climate change is brought to the front burner. Rhetoric should be over, and it is time for action. And I want to see at the end of COP30, countries will be taking concrete action to deal with this existential threat to humankind.
Okay. All right. Thank you very much. Lawyer, your reflection.
Yes, thank you too for the opportunity, at least first time in studio. It's just 4 days after Infanspem won the national assembly.
Oh, dear Lord.
I think that there should have been a banner behind. Congratulations, Infanspem. Yes, I'm a butcher boy.
Oh, okay.
Yes. Are you?
No.
Okay.
When was the last time?
Oh, last year.
Oh, last year.
And we are winning next year too. You know, next year is Infanspem's 150th anniversary. And
I attended a school called Badubonso Senior High Technical School. Have you heard it before?
No.
You haven't?
Well, in relation to senior high schools, I remember doing the conversation, watching the vetting yesterday. They referred to Justice Dennis's school, which previously was a mixed school and is now a girls' school. And no, it's now a Fiakobi, but previously it was a mixed school, it's now a girls' school. I don't know. But yes, congratulations to Infanspem. We are proud of the boys the second time. Next year, marking 150 years of celebrating secondary school education in Ghana, and Infanspem's 150th. We hope to win it and complete the three-peats. Also, special greetings to all the aspirants for the MPP race. I know it's not an easy feat, touring the country, the risk involved and all. A special one to Honorable Kenneth Japan, who is obviously my candidate. There's something I want to talk about briefly in a minute. It just came to mind after you were speaking about COP. It's something I've observed, and I think I chanced upon it. Same thing is happening in Nigeria. The fact that in Ghana and actually in Africa, our politicians a lot seems to try to seek some validity from our diplomatic missions, and this cuts both ways, both parties. When issues happen that can be addressed through our internal processes, you see members of parliament marching to the Dean of Diplomatic Corps to present a petition. I don't know what kind of resolution we seek there. We see former presidents gathering diplomats to report our security agencies and other agencies to the diplomatic missions. This is what gives them once you do that, you present petitions to them, you now invite them to intervene. This came to mind when I was looking at the situation in Nigeria and in relation to President Trump's comments that he wants to intervene in Nigeria, only to read more and find out that there were actually petitions to the U.S. Embassy to intervene. Yes, I believe that there may be instances where, in extreme circumstances of human rights violations, where local systems don't work at all, such remedies can be taken to bring a spotlight on the country. But ordinarily, no country has perfect systems. And in a country like Ghana, even though we don't have perfect systems, we are still growing and developing our processes. So if we tend to seek some external validation by always going to our colonial masters or diplomatic missions to come and help resolve our issues, then there's always going to be that interference. And the effect is that we are not going to get our institutions to properly develop as we want to be. There's always that foreign interference. So that is one issue that it's something I actually want to write about, but it's one issue that I'm really concerned about. We have our institutions, let's develop them, let's grow them.
Okay, all right, thank you very much. Eva,
yep.
I want to start from your end.
Shall we start?
Yep.
Okay, so the Daily Guide this morning is reporting the obvious. Minority boycott CJ nominee amid drama. And I'll start with you, lawyer, even before I come to the politician. I saw that he showed up with it. Is he? Yeah. Well, this disclaimer is so nice.
You are a politician with title.
I take that back.
He
even has
one
a candidate.
Of the leading campaigners of
Kennedy Japan. Okay. You see?
I'm a lawyer first.
He's a lawyer first of all. But I'd love to hear from him. Why? Because...
You want me to reveal something?
I love the revelation.
Ken is not going to win. But there are plans in maybe next whatever years when Ken, if he will become, he has a portfolio, cemented for him.
Oh.
You know, sir.
Yeah.
There's no portfolio cemented for me.
Our
brothers for ADC, they think that it's going to be more difficult for them to contest against Ken. So at every chance, they make a first comment, Ken is not going to win, just to paint the picture that Ken is not going to win our primaries. But he's a stronger candidate. He's the strongest candidate you can ever face in 2020.
Oh, no, as for that, I've already said here, and MFI will bear me out, that whoever you bring in 2020 is going to face a humiliating defeat.
Why would I bear you witness to this?
I said,
of course,
made that declaration
a lot of time.
when you were hosting this.
But you know why I want to go to him first? It's also because of the nuance within the NPP party and because it's the minority that staged the walkout yesterday. So I want to hear, his position on the entire process yesterday, what happened yesterday first. Then we'll go into the detail of the questions. Yeah.
All right, thank you. I watched it yesterday. I had to rewatch again this morning. And so I have a few takes. First of all, I think the first question, even for non-legal minds, is the Chief Justice, Araba Sabatokon, has been removed, and she's challenging the matter in court. Now, in the process that this new Chief Justice is confirmed, and court also believes that her removal was, or the court quashes her removal, what happens? Do we end up having two Chief Justices? Do we have to reverse the appointment of the old Chief Justice? What process or what lay-down process is even there to follow? Does that automatically, if she is reinstated or if the court quashes the decision of the committee and the president's warrant, would that now give us a situation where we now have to go through court or through a process to remove the newly appointed Chief Justice? These are all questions that nobody would have answers to, and the process may have to reveal it later. So why bother put ourselves through such a potential situation where we can wait?
Who's complaining?
Ghanaians.
The process is the... You see, the law would be the law, right? But at every point where there's no law, when you go through the process, it gives birth to another law. Why would there be a challenge?
The process now has been challenged. The process of her removal has been challenged. Now we have an acting Chief Justice. Don't get me wrong, I am the biggest fan of Justice Baffoe-Bonnie. I even think that he should have been Chief Justice way earlier. So, but the removal of Justice Tokonu has been challenged. And the matter is still sub judice, the matter is still in court. So, simple question, forget legal minds. If she is reinstated, and this is what she's seeking to do in court, and if there's a legal path that she's following, and I don't want us to prejudice what is going to end up in what the court is going to decide on. And of course, she's been Chief Justice, so she understands the legal processes she's following, and the lawyers understand the legal process they are following, and there's a likelihood, I'm not saying that is going to be the outcome, there's a likelihood that the decision may be annulled, or the court will say, okay, you are reinstated.
Legally, usually when it is annulled, what happens?
So now the process will be, okay, she wants to be reinstated, that's the remedy she's seeking. So if the remedy is accepted by the court and she's actually reinstated, when someone else has been appointed, what do you think will happen?
Legally, what would have happened?
No, so now legally there will be two Chief Justices, unless the court makes an order.
Two Chief Justices, would they not?
Exactly, so that's the challenge. No. Unless the court
if you reinstate one person, there's one position. So if you're reinstating somebody, wouldn't that be an automatic removal?
So it has to be an automatic removal of a legitimately appointed Chief Justice.
But wouldn't it mean that the appointment vetting, nomination, vetting and approval was null and void. Isn't that what you say in law?
Fine. So why do we go through that process?
But why do we go through the whole process of removing a legitimate Chief Justice?
No, but you see...
Because if you look at Getchu Tokono, her ladyship, right, it's not as if she was not legally put there. She went through the process. Yes. The then president nominated, she went through parliament, vetting and all of that. And when it was petitioned that she should be removed, they followed the process. Why would we now be surprised that there would be a process to follow if there has to be a reinstatement?
So you see, at least for what the decision was, her removal was based on stated misbehavior, right? I know that in law, I think some people cannot stand on anything, like, because maybe, so it means this whole process might have been void. But I'm saying, why do you take someone like Justice Baffoe-Bonnie even through this whole process where you go through nomination, you go through vetting, you are appointed, and through no fault of yours, they said your predecessor was not removed the right way, so you have to go back. It's
interesting because
when you can wait for this process to be exhausted and there'll be finality.
You know why I'm actually fascinated? Because I think he really understands the law and the processes better. So how he would subject himself to something he cannot predict, because laws should be quite predictable, right? So if Justice Bonnie himself allows himself to be going through the process, vetting and allows it.
He's been appointed. He's been nominated.
Exactly my point. So what then should Parliament do? Because that's a constitutional requirement that when you are nominated, you should be vetted.
Exactly. So my point is that I think that Parliament could have taken its time. Now, yes, we have a Chief Justice in acting capacity. Or truly and obviously, a person in acting capacity may not necessarily have the same powers as a substantive Chief Justice. But at least through and during the pendency of these current processes, the Parliament could have taken its time. Let the matter travel, because the matter is in the High Court. Let it travel. Let's ensure that maybe measures are put in place to ensure there's a speedy trial and decision-making in those instances. When finally a decision is made on whether or not Justice Tokono rightfully or has a right or her claims may be upheld, then you can now finally vet the Chief Justice nominee, make him Chief Justice without being subject of this whole control.
Who are you speaking to? The president who nominated or the appointment committee that did the vetting? Because I only see the appointment committee doing what the Constitution mandates them, right?
Now the matter is before Parliament, and that's the minority leaders' motion to Parliament was. I think that Parliament should have taken its time and halted the process. The president, you are past the president's stage. The president has done what he wanted to do or what he had to do, but now the decision is before Parliament. So I think that the ruling of the Speaker should have looked at a way where we could have halted processes to a point where there was clarity as to what was going to happen in the end.
Let's bring in Honorable Chedria here. Now, doesn't the minority have a point when they say because of the former Chief Justice challenging the process in court, Parliament allow the process to elapse before you go ahead to vet? What would it have taken out of the whole process if Parliament had waited?
Not at all, Kojo. It is not as if the matter was not dealt with in Parliament. But let me begin with Article 144(1), which says, the Chief Justice shall be appointed by the President acting in consultation with the Council of State and with the approval of Parliament. President has nominated Chief Justice, acting Chief Justice Baffoe-Bonnie in consultation with the Council of State, and there is something called formal communication to Parliament. President executed that. It came to Parliament, and the Speaker read the formal communication in Parliament. The issue was debated. Minority came with a motion to kill that communication for Parliament to suspend the vetting. After lengthy deliberations, Speaker made a ruling. And the ruling was that the pendency of that case in court does not stop Parliament from performing its constitutional duty. 2, Parliament was and has not up to now been injuncted by any court of competent jurisdiction. And for that matter, if Parliament fails or neglects to perform its constitutionally mandated duty, then it is rather the parliament that is breaching the constitution. So by performing the constitutionally mandated duty yesterday, parliament fulfilled its obligation to the state in that realm. Let me go further. In 2012,
so you're saying that if, say, I have been in court and I'm seeking some reliefs, and I say my rights are being abused. You're saying because the president has made a nomination to parliament and parliament has not been injuncted, parliament does not have that duty to uphold the right of an individual.
We are upholding the right of an individual. Also, if somebody has been nominated and you fail to vet, you are rather trampling upon his right to assume the seat. So we were rather upholding the rights of individuals by giving everybody fair playing field. Kojo, don't forget, this acting Chief Justice has been in acting position for 7 good months. That was in April 2025. And you know, when you are in an acting position, there are certain things you cannot usually do. So for 7 good months, we don't have substantive Chief Justice in this country. And the case is in court. Nobody knows when we will see to the conclusion of the case. Then we keep waiting. And let me ask.
Why is that?
Let me ask. When Nanado went to court to challenge the validity of the election of President Mahama, were you saying the parliament should have suspended swearing in President Mahama, waiting until the determination of the case? And if that had been the case, we would have waited until August. And when President Mahama challenged the 2020 elections, did you hear anybody say, oh, President Mahama is in court challenging Nanado's eligibility to be sworn in, so don't swear him in? The point I'm building is there is no irreparable damage caused. Let me stress, no, he's a lawyer and he knows. And I will ping him down because I've heard him on One Breath, another platform some time ago, arguing. And that has been the position of almost all lawyers, that pendency of a case in court should not necessarily stop constitutional duty bearers to perform their duty. So why are we now shifting the goalposts? And I'm saying there is no irreparable damage to her ladyship, Justice Tokondo. If the case goes in her favor, what is going to happen is the court will order for her to be reinstated, and all her lost earnings during that period that she has been out of office will be restored.
Reinstated as a Chief Justice.
Oh yes.
But that's strange. Let me just interrogate a bit before you add on. If you say there will be no irreparable damage, she was removed based on misconduct.
Yes.
And I don't know how much reinstatement will take away that the basis on which she was removed. Misconduct, which had become a center of discussion all this while, that is not measurable. No, how do you calculate that as
irreparable? Now, if you go to court and you win the case, that in a way cleanses whatever allegations, because you've won the case. So it means the allegations that led to your removal were fabricated or had no grounds. And that restores your dignity. He's a lawyer. That's why you go to court. Somebody has made allegations against you without foundation. You go to court, and when the accuser is not able to prove his allegations, then your dignity is restored, with damages sometimes also being provided. So there is no damage. There is no irreparable damage. You see, when you go to court and you're seeking for injunction, one of the key things the judges will rely on is what irreparable damage is going to be caused if injunction is not granted. One, those who are in court have not been able to convince any court for an injunction to be granted. So what stops us from performing our constitutionally mandated duty. When MFR, as you rightly put it, once the judgment goes in favor of the removed Chief Justice, the status quo will be restored. So you don't lose anything at all. But if we say, because somebody is in court, everything should come to a complete halt. People have suggested, oh, you are already acting. But we know the difference between a substantive office holder and acting office holder. So for 7 months, and you know the role judiciary plays in our democracy, it is so significant that we cannot afford to wait any longer. And I think the Parliament was right, the Speaker was right, the Chairman of the Appointment Committee was right, and in this instance, the only person who was wrong is the respected minority leader and his colleagues.
Weren't they taken by their principles to say that we support the process in court, and therefore by that, we cannot be the same people, contributing to this process when we are against.
So, if you're a Democrat, in Parliament, motions, debates are taken. At the end of the day, vote is taken. So, you have your say. If it doesn't go on your way, does it mean that decision is invalid?
It does. They don't want to be part of it because, in principle, they are against that process.
They have the right to walk away. In fact, walking away from parliamentary proceedings is a tool of registering your protest. But for us, on this occasion, they did not have any strong reason for which they walked away from the vetting.
Are they wrong to walk away when their principle is that?
No, they are appropriate. That's why I said when Danado was challenging President Mahama and President Mahama was being sworn in, nobody called for the swearing in to be held on until the final determination.
But the MP boycotted the swearing in.
But when President Mahama challenged Danado, what happened? Danado was sworn in, yes, and they all supported that. No, the pendency of the petition at the Supreme Court should not stop President Akufo-Addo from being sworn in to perform his constitutional mandated duty. The point is, Kojo, in the national interest of the nation, should we still have this vacuum? We may have an acting CJ, but he's limited in what he can do as an acting CJ. So, in the interest of the nation, it is very important, especially if there are no processes to restore whatever you've lost. In case you win the case in court, that would have been different then. Okay. But there are avenues for whatever you've lost to be restored in case you win the case. So this should not be an issue of contention at all, unless people are doing, downright politics with this issue. And it appears MPP as a political party has taken a serious stance on this matter. And Kojo, this is what we've been talking about. We all talk about judiciary should be independent, should not be politicized. But what we're seeing, clearly, you can see politics at play. President is performing his constitutionally mandated duty. Where has he breached? And in any case, when the issue came to the floor of Parliament, Speaker made a ruling. You come by motion. If you lose the motion, what do? There are processes to challenge the motion. Why was the ruling not challenged until you come to the Appointments Committee to come and raise the same issue? Because the tennis, all committees of Parliament are extension of the chamber. So issues that have been dealt with at the floor cannot be dealt with at a committee, because committee work they are doing, what they did yesterday, do you know, that is not conclusive. It will come to the plenary, the chamber, for us to debate. So even though the Appointment Committee may pass the nominee, at the plenary, we have the right to reject. And that is the final. So at the committee, the committee's decision is not final. It comes to the plenary for all the 276 of us to debate and whether we will reject the recommendation of the Appointment Committee or endorse the recommendation, that is when the processes will come to an end. So they may have run away from the committee. The report will come to the plenary.
At the appointment committee level, because of course in Parliament you say that 275 people argue.
You don't have the numbers.
Debate, but you have the numbers. That's the matter. Two things I want to ask. But I've seen in this country where some cases are quite expedited.
Okay.
Because of the sensitivity of the case. I like to think that it's not just the minority in Parliament that have concerns about whether or not the Chief Justice's substantive issues that are in court haven't been listened to. It is almost as if she's just been going to court and never ending because she's not seeing finality to it. For such a case, and knowing that if you vet this Chief Justice, he is likely, or he is the one who will empanel judges to sit on her case, and you go ahead to vet, why didn't we set a priority where we seek some finality to her case, and then we can also go on with appointments because of conflict of interest issues?
So are you suggesting when...
I'm asking a question, not
he empanels
there's a thing called conflict of interest.
Supreme Court judges are going to pander to the whims and caprices of the...
There's a thing called conflict of interest. It's not that...
In any case, MFA, without being approved as a substantive Chief Justice, if he were still an acting Chief Justice, he will still be empaneled.
I mean, you have said that there's a difference between an acting and then a substantive.
But for empaneling, so today, without his nomination, until his approval, if the case is listed for hearing, he will still be empaneled. So it doesn't matter whether he's acting or whether he's in substantive position. If you think his presence will influence the judges, I mean, nothing will change.
No, but would people be wrong to nest this idea and this perception?
But that would be an insult to the intelligence and the impartiality of the revered Supreme Court judges. No, you have judges who were appointed by a particular government or a particular regime. Cases come and they vote against that regime. Don't we have that? If we go in by the elevation of our Chief Justice Baffoe-Bonnie, he was appointed to the Supreme Court by His Excellency John Ajikum Kufuor. 2 years in an appeals court. 2 years, he elevated him to Supreme Court. But so going by, I mean, the analogy of MPP, they should rather be very comfortable with Chief Justice Baffoe-Bonnie because he was elevated to appeals court, moved to the Supreme Court by President John Ajikum Kufuor.
But I'm not sure that matter, I'm not sure their uncomfortability is with the person. They made that known. They say their issue is with the process, not him. Not so. Yesterday, the minority leader said they don't have an issue with the person. They
described him as disputed nominee.
Oh, but not with the person.
So what is the dispute about his nomination?
They're talking the process.
No, there's nothing wrong. The Constitution is clear that the nomination should be done in consultation with the Council of State. Was that done?
That has been done.
And there should be formal communication to Parliament. Was that done?
Yeah.
And
there's always been debate about portions of the Constitution when it comes to interpreting of it, because then people will read it and impute their own interpretation and all of that. So we shouldn't act surprised when a person has an issue with a process that has been laid down.
You're talking about the processes. Can you pinpoint any aspect?
I'm not sure.
Or those who are arguing about the processes, have they been able to pinpoint any aspects of the processes?
Their case has been with that there is an unresolved case in court.
No, but he's a lawyer. That's what I'm saying. That
let's go to the lawyer.
In fact, when a case is pending in court, does that stop all other constitutionally mandated bodies to perform their duties? Even he knows when he goes to court with clients and they are litigating over land, an injunction has not been granted, he will advise his client that go ahead to do whatever you are doing because there is no injunction restraining you from doing whatever you are doing. So if they are minded, they should go to court, injunct everybody from doing whatever we're doing. Until that is done, the Parliament will continue. And the ruling was clear. I've seen the respected minority leader going to court on several occasions. Speaker made ruling on those parliamentarians who had left their parties, and Speaker made ruling. Didn't the respected majority leader then go to court to challenge that. So when Speaker ruled on his motion, if he was not satisfied, he could have gone to court to challenge that. And if court had ordered that you could not proceed with the vetting, probably that would have been a different ballgame, because when Justice Tokono and her team ruled that those members cannot be expelled from Parliament, Parliament complied. They went back to Parliament, didn't they? So I'm surprised he is not using the same processes. So the issue is you cannot approbate and approbate and reprobate at the same time. Minority came to the appointment committee. I was there, well rehearsed and prepared to come and dramatize, to come and cause confusion, and later walked out. So it was well rehearsed. In fact, we heard it even from the corridors of the minority 3 days ahead. But
these are your colleagues, and you are referring to their actions as drama.
Oh yes, but that was.
What if it's a serious matter? Think about it. What if it's a serious matter that's coming across as drama? But you hang on to that. Let's go to the lawyer at least for some. Is there a provision in the Constitution that says that when the president nominates, the appointment committee or Parliament must vet within a specific time?
No, I've not seen. I don't know if they have it in their rules, but I've not seen any provision that gives specific timelines for nomination. I'm actually looking for, he's a parliamentarian, your rule on sub judice. If you could find it for me, I'll be glad.
Okay.
Yes. So a very important point that we've not discussed yet is the effect of prejudice or the prejudicial effect on the courts. You see, even in Parliament, they have a rule on sub judice, meaning you cannot, when a matter is sub judice or when a matter is before the court, you don't have the opportunity to comment on that. Why? Because of a weight Parliament has as an arm of government. When you discuss matters which are pending before courts, it has the tendency to prejudice the minds of the court, let alone make a decision on something that is actually pending before courts, which effect will be much more stronger than even commenting on this issue. Look at this scenario where the Chief Justice who has been removed is challenging her removal. Now, before that matter will be heard, Speaker and Parliament will have gone through the process of vetting, submitting a name, and the appointment of a new Chief Justice. Now, what then becomes, and what value would that have, or what effect would that have on the courts? It will even make it difficult for the courts to impartially decide on the matter. And it's for that reason that there's even that rule on against sub judice in their standing orders, just to prevent the prejudicial effect on the courts.
But lawyer, he makes an important point.
Yes.
By referring to the swearing in of the two presidents.
Are you suggesting one?
I'm coming there. So you see,
the case
for that,
is dead on arrival.
There's a clear constitutional provision that talks about the process and when the president should be sworn in. Okay. So for that, there's a clear constitutional provision. And you see, in the absence of a president, who stands in the vacuum? Yes, in few instances, the Constitution says in the absence of the President and the Vice President, the Speaker of Parliament stands in the vacuum. But the Speaker of Parliament actually belongs to a different arm of government. So it's totally different and I don't want us to confuse this with that of the Chief Justice. Here we have a Chief Justice, and in this matter, the senior-most judge of the Supreme Court, who is in acting capacity. It's different from a situation where the Constitution prescribes that on the 7th of January, we should swear in the president. So here, the Constitution clearly talks about the processes. And I think that even by virtue of that was the reason why there was a new constitutional instrument that sought to reduce the timeline for decision-making in presidential election petitions so that you can easily resolve, and whatever happens, you move on.
But even though the Constitution gives a timeline within which the president has to be sworn in, if a case goes to court, his argument is that, per your logic now, if that case in court, then of course it restrains Parliament from going ahead to swear the president in, even though the Constitution says.
No, but the Constitution gave a specific
It gives a specific timeline.
Yes.
So I get it. The Constitution has prescribed what should be done.
I get it, but he says that per your logic today, that because the case is in court, Parliament has to restrain itself until the case is dealt with. The same way, even though the Constitution gives or prescribes a date on which the president should be sworn in, because the case is in court, then Parliament is restrained.
I think that the first one, the lawyer should speak. Make your point.
Yes. What I'm saying is that for the presidential situation, there's a clear timeline that is prescribed by the Constitution. And the Constitution does not talk about any compromise.
Okay.
And if you look at it, even logically, there are three arms of government. These arms of government are actually independent and they should function as such. It's in limited circumstances where, in the absence of the president and the vice, the Constitution actually delegates the Speaker of Parliament to be in acting capacity. So we can't have a country where we only have two arms of government functioning. That's the judiciary and the legislature, with the Speaker acting as president for a long period. But here, this is a different situation. In this situation, we have a full arms of government, which is the judiciary, fully functioning, with the Supreme Court, with the senior most justice of the Supreme Court being in acting capacity. And let's understand the fact that, yes, we say that someone in acting capacity does not have the full powers of a substantive Chief Justice, which is true. But almost all the important things that a Chief Justice in acting capacity can, a substantive Justice can do, a Chief Justice in acting capacity can do.
No.
So it's not as fatal. I said almost all the important things. I chose my words very carefully. I didn't say everything. So it's not as fatal. So comparing this situation with that of the presidency is like comparing our apples with oranges.
Okay.
And in that situation, and even that, trust me, I still think that it has some sort of a prejudicial effect. I mean, the law and how the law operates and how judicial decisions are made are different things that I may not want to go into. But I think that even when we have opportunity to, in relation to the amendment of our Constitution, timelines for elections, I even think that that is something that should be looked at. Because once there is already a president seen, a president working, a president acting, it may be difficult for a bench or a panel to decide otherwise. Yeah. So in my opinion, that's why if, let's say, we talk about having elections earlier, maybe around November, we could have a process where the dispute resolution process could be earlier than the swearing in with strict timelines.
Yes, the CJ nominee sort of says something that in Kenya, they do within 21 days. So he is going to bring a legislation that will seek to reduce the time.
Exactly. So even with that, I even believe that when there is process for disputes, because of the prejudicial effect, it should be done earlier. But now look at the current state of our Constitution. Here, there's strict timelines. In the instance of the Chief Justice, there's not. And I don't think that waiting for a few months will hurt anything.
Especially waited for 7 months.
Especially 7 months when?
Yes, when he was suspended.
Which
7 months.
He's been acting for 7 months.
But that time she was still.
But I'm quite curious
there was the Chief Justice. She was not removed for 7 months.
So why didn't we just? I know that there was a legal break and all of that. It means that the acting Chief Justice has all the power to empanel.
Yes.
Is that everything? Truth is, has administration of justice not been?
No, Kojo. The issue is the Chief Justice, acting Chief Justice, will only empanel when the case has been listed.
How is this important case not listed?
It's not the Chief Justice who lists cases.
So yes, I get it. But why is this?
It's the Chief Justice who lists the empanels. It's not.
No, but so the whole point is that the Chief Justice is the one in charge.
I don't want us to do politics. But prior to December, serious cases that NDC had filed in court, some over 1 year, 2 years were there. Afenyo Americans went to court the same day. The then Chief Justice saw the need to empanel, adjudicate, gave ruling on that very day. So don't let us talk.
But I'm asking that. Don't let us. Such an important case as the former CJ challenging the removal process. Why has it not been listed on this?
So is there any timelines like you are saying for the presidential petition? They say 42 days. So has anything been breached in the Constitution for that matter, not having been dealt with? Ankwajo, this thing we are talking about, we are not discussing in vacuum. Supreme Court has made an emphatic ruling recently in the Vincent Assefue's case that when cases are pending, they should not hold the hands of constitutional bodies from performing. So there is a recent ruling in Vincent Assefue's case, and he knows. He's a lawyer. For 7 clear months, Are we not in a country where we've all been complaining about people being put in acting positions, and they will be there for 6 months, a year, they are not being confirmed, and we are all complaining about that. So for how long should the acting Chief Justice be in acting position when, especially, there is no definite timelines for the case to be dealt with? Unlike in the case of the presidential pardon, within 42 days, it must be dealt with.
Final question for me on this
in litigation,
yesterday,
you cannot put
the majority
timeline.
Have a problem with the terminology disputed. If you look at her judicial review that she's seeking in court, if you look at an order prohibiting consideration and appointment of a new substantive Chief Justice, why is that?
So if you are in court and there has not been a ruling, because you...
If there's a ruling, then the matter is not disputed anymore. No, if you rule on the matter, then it's not...
No, then you can say you are... So who is disputing?
The Chief Justice, among all of the reliefs that she's seeking, the removed Chief Justice,
you see?
she is also seeking. So can I ask this question because there seemed to be a concern about the use of disputed nominated Chief Justice.
The issue is she is disputing her remover. She's not disputing... There is no dispute about the nomination because the nomination is grounded on Article 144 of the Constitution. Is there any dispute and ambiguity about that?
That's what she said. It was her claim. One of her reliefs she's seeking is the process to be halted.
It amounts to
so that becomes a dispute. That becomes an issue to be resolved by the courts.
146.
You said?
It's not the 146.
That becomes an issue to be resolved by the courts.
144.
Beyond the 146, she is seeking an order prohibiting the consideration and appointment of a new substantive Chief Justice of Ghana.
So has that been granted?
If it's granted, then it's no longer disputed.
Once that has not been granted, nobody is stopped.
You see, once you do the thing, you are going to render that claim negatory.
Yeah. No, not negatory. Not negatory.
Because, okay, so after the vetting, what will the court decide on? If the person has now been approved and has now been vetted and approved, what is the court?
No, the court will give consequential orders. What to do? Consequential orders when court is affirming or court is affirming the position of the former Chief Justice, there will be consequential orders as to what to do. So there's no dispute about that at all. So my point is that 7 months is enough. The Chief Justice was appointed by this very Constitution, the former Chief Justice, and this same Constitution removed her from office. Nobody is stopping her from pursuing what she sees as injustice. But also, nothing stops Parliament from performing its constitutionally mandated duty. So, what happened yesterday, if anybody is minded and thinks anything in the Constitution has been breached, that is why the court is there. And the law will always be the law. So, I'm looking forward for that process to be challenged. It was challenged on the floor of Parliament. They lost. So if they think there is still something in it, then you go to court. In fact, I'm very surprised the very people who have used courts over the years to fight these matters are now running away from court. No, but the process yesterday, I'm saying I want to see going to court to challenge.
Someone has already, MFA, may I?
Please.
Yes. So the matter is already being challenged in courts, and that is what the minority leader was trying to draw the attention of the court, of the plenary, of the speaker, that this matter is already being challenged in court.
Then it came to the plenary and was dealt with.
I'm saying that the matter is already being challenged in court. So you want him to...
If it's dealt in Parliament, does it mean that it cannot be dealt in it's not in the court anymore?
No, it's at the court, but what I'm saying is it cannot be dealt at the committee. Once it's dealt with the...
He didn't seek to deal with the matter at the plenary.
With the speaker, you know?
He didn't seek to deal with the matter at the plenary. What he said, he was given a preliminary comment on the vetting. He didn't seek at all to really litigate the matter that had been decided by the speaker.
Lawyer, you were a lawyer and you know this.
Yes.
In the plenary, the respected minority leader came by motion.
Yes.
And the speaker, you know, Parliament, we have the speaker.
Yes.
We have speakers, 2 other speakers. And the speaker himself was presiding, dealt with the matter, made a determination on it. Then you bring the same thing at the committee level where one of the deputy speakers was presiding. And he cannot make a determination contrary to what the speaker had made.
So I watched this twice. This is what happened. The minority leader, was not seeking to relitigate what had been decided by the speaker. When the nominee was brought before the committee, the leaders were given opportunity to give their preliminary comments. It was in that preliminary comment that the minority leader made those statements he made, clearly showing disapproval for the decision that had been made by the speaker. But he was not
the very issue you brought to the
so can
floor.
He not?
And let's be clear. Did you listen to the majority leader?
Yes, I did.
The issue of the preliminary comment.
Yes.
It's not right of leadership. It's a privilege. They say when committees.
It's practice.
No. But
it's practice.
No,
but there are occasions they are waived. The chairman decides.
It wasn't waived in this instance.
I've been at various committees, so I'm telling you the rationale behind that. If you try to use that privilege to abuse people, that's where the problem is. So it is not as if it is a right.
But if I could
it's a privilege.
Make a comment, not on the substantive matter we are discussing. I think that the biggest problem yesterday was how the deputy speaker controlled the committee. In the sense that, as a deputy speaker, he should have taken charge of what happened in the committee. Now, the minority leader was making certain comments which were being objected to at every point in time. Like every line was being objected to. That's fine. But what he should have allowed in relation to how he was controlling the committee, he shouldn't have allowed that to go on throughout the process. In my opinion, he should have allowed him to finish making his statement.
All right.
Then they could have objected to either the whole statement or those portions.
Your point is well made there.
No, in Parliament, when point of order is raised, it doesn't matter. When point of order is raised, you have to be stopped.
Okay.
And the order, point of order,
thank you very much.
Should be listened before you proceed.
Nana Ikwamo Boateng in Ablekuma Central says, okay, Dr. Bawumia will lead MPP into victory 2028. One cannot believe, you use some words, I'm not going to use them, in the conduct of Mahama Yarga in yesterday's vetting. The majority in Parliament are so intolerant to the extent that a ranking member of a committee cannot express his opinion. Is this what the NDC wants to use their supermajority for? The NDC have succeeded in destroying our judicial system. He brought in Nana Ikwamo Boateng.
I totally disagree. Are we not in this country when social media commentators all believe that the chair and the majority have been bullied by the minority at appointment committee sittings? In fact, it is the chairman and our leader who have been accused of not being, strong enough.
Thank you. Thank you. We're grateful to you. Honorable Dixon Chreddia is MP for Brekum West. He joined us there. And also, Kobe Amwa is lawyer. He joined us as well. Thank you very much, gentlemen, for joining us. Well, we'll take a break here. We will be back with much more on the AM show. Do stay with us.